Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be talking about the right to know law and the payment side of that law. It's an area that is kind of interesting because there's a lot of misunderstandings about this aspect of the right to know law. A lot of people think it's free and it's not. So we're going to be talking about what agencies can and can't charge for, and just some things that people need to be prepared for when they go down this path of filing a right to know request. A couple preliminaries before we jump into the presentation itself. First, this session is essentially a PowerPoint presentation with me talking in the background. The PowerPoint is available on the Office of Open Records website. The URL for that website's on the screen right now. I think you go over to the training tab, click on that and scroll down a little bit, and you'll find all of the PowerPoints that we use for our training, including these webinars. You're more than welcome to use any of them. Perhaps you have a colleague who couldn't attend today. Maybe you're doing some localized training and you need some resources, or perhaps it would just be helpful for you to have it available for your own future reference. Feel free to download it at no cost and use it as you see fit. Also, these sessions are being recorded. The recordings are usually ready a couple days after the presentation. And if you're interested in watching it again or listening to it, whatever, you can contact our office and one of the administrative staff. I believe the way it works is that they send you a link, and then using that link, you can get into the recording. And I believe that the recordings are also posted on the website, the most recent ones by the variety of topics that we have for our different webinars. Again, maybe you have a friend or colleague who couldn't make it this morning, or just for your own future reference, feel free to use them as you deem necessary. Finally, there is the opportunity to ask questions today using the chat feature. Type in your questions and I'll do my best to answer them as we're going through the presentation. But you need to help me out with two things. First is, we're talking about the right to know law and payment issues, so let's try to stay on topic. But more importantly is it really helps if your questions are direct, short, and to the point. Reason being, every so often someone will type in, what seems like pages and pages for a simple question. And it's just very awkward for me to sit here and read through that while everyone else is waiting patiently, silently for me to figure out what the heck is going on. If it looks like you've got a situation that is, unique to your jurisdiction or your group of facts, or maybe it's some unusually complex question, we'll do one of two things. We'll wait until the end of the presentation, and I'll do my best to come back to it and answer it online for the good of the order, or we'll take the conversation offline, where I'll just encourage you to phone into the office or send us an email. And the process is such that regardless of which avenue you take, it first comes to our administrative staff. They are very well versed in the right to know law and can help you out. But if you happen to stump the panel, your question will get escalated to one of the senior staff. And they do their best to get back to you as soon as possible. I used to say within 24 hours, but honestly, things are so busy here lately with appeals that I can't guarantee that 24-hour threshold. But we do our best to get back to you as quickly as possible, because we figure there's a good chance that if you're contacting us, it's something that's, it's important. Plus, it's probably time sensitive because of the deadlines that everyone faces on both sides of the equation, both as a requester and as an agency when you're dealing with this law. And if you're curious about those deadlines, then I would encourage you to sit in on our webinar that deals with the basics of the right to know law, where we go over those deadlines as one of many parts of that topic. Okay, I think that pretty much covers all the preliminaries. So let's go ahead and jump into the presentation itself. Okay, within the right to know law, there is a provision that gives the Pennsylvania Office of Open Records the authority to establish a fee schedule within certain parameters. That fee schedule can be found on our website. Again, another tab under the right to know law. Just scroll down and you'll find that. That fee schedule is reviewed every 2 years. And I can tell you from personal experience that what we end up doing is using social media to let everybody know that we're getting ready to review the fee schedule, and that if they have any comments or concerns, please let us know. And I can tell you from personal experience that based on comments solicited from the public, we have changed the fee schedule. So it's important that if you do have any concerns about certain financial aspects of the right to know law and what you can and cannot charge for, let us know. Send us an email, call the office or whatever. And your comments are taken seriously, and we will respond accordingly. In essence, the fee schedule is that agencies can charge up to 25 cents a page for a single-sided black and white 8.5 by 11 or 8.5 by 14 sheet of paper that would be issued when an agency is granting a request for hard copy. And it's 50 cents a page for color. Now, that's the nuts and bolts of the fee schedule. However, the fee schedule includes much more than that. And if you look at the bottom of this slide, in bold and in red, I say, read the footnotes. Okay, why is that important? Because there are exceptions, and there are exceptions to exceptions. And if you go down and look at the fine print at the bottom of the fee schedule, it goes into detail in explaining what some of those exceptions are, or what most of those exceptions are. What will happen is that our office handles appeals. That's really the bulk of the activity of the Office of the Open Records. And as a result of some of those appeals going up into the state court systems, the Pennsylvania Commonwealth Court, the Pennsylvania Supreme Court, they will issue decisions on court cases for right to know cases that oftentimes deal with payment issues, because you can appeal if you think that you're being overcharged by an agency or charged for something that you think is inappropriate. So the courts will issue clarification on, okay, this is what this aspect of payment issues for the right to know law means. And as a result of those decisions, we will often parse them out and put a footnote down at the bottom. So if you look at the fee schedule, go down to the bottom, and you'll find all those footnotes, which in essence are the courts clarifying that in these specific situations, or if these facts are present, then this exception comes into play, thus the footnote. So don't just look at the main points of the fee schedule and think you understand it. Because oftentimes you will find down in the footnotes, it's like, aha, okay, this is what the fee schedule means, unless, and then you get into the minutia of what an agency can and can't charge for, and under what specific circumstances. So, look at the footnotes. Now, I should just point this out real quick. And this is one of those changes that took place as a result of people contacting us when we were revising the fee schedule, is that if you should submit a right to know request and the response is really large, if it exceeds 1,000 pages, Once you get up above 1,000 pages, the agency can only charge up to 20 cents a page for that single-sided black and white 8.5 by 11, 8.5 by 14. You're thinking, well, when would that ever occur? A quick example might be with a PennDOT a PennDOT construction project where there are a lot of right-of-way considerations, an environmental study, et cetera, and an environmental group, and it's not unusual for an environmental group to come in, want to see the records that were generated by the environmental engineering group preceding construction of the project, and that would easily exceed 1,000 pages. We have had right to know responses in excess of 20,000 pages. It just depends on the specific circumstances, but that's just one of those points. I put it out there not so much to show you that suddenly your costs go down if it exceeds $1,000, but just to send home the point that your comments mean something to us, and we do periodically change the fee schedule when a valid point is raised by someone who is submitting comment in response to our solicitation. Okay, let's move on. I mentioned pass-through costs. Okay, let me try and explain what that means. Okay, these are where actual costs can be documented by the agency in excess of what they would otherwise charge per the fee schedule. The easiest one to use as an example is postage, okay? Let's say the scenario is such that someone submits a right to know request and they want the response printed out on hard copy and they want it mailed to them, okay? Well, there's the 25 cents a page, which you would document consistent with the fee schedule, but then you have the cost of postage. Many government offices have postage meters. So you would take those printed pages, put them on your postage meter, have it calculate how much would it cost to send this group of records to this particular address. And let's say the postage meter says $3.15. Well, that $3.15 is a documented pass-through cost that the agency can then add to the invoice to charge the requester for those records. Another example might be outside copying fees. Someone submits a right to know request for a copy of a blueprint that's been projected for a new subdivision within a township, okay? That blueprint, it's been determined, is a public record. So we're going to release it to the requester. However, the township does not have a large-scale copier, something that can reproduce something as big as a blueprint. So they have to run down to Kinko's or the local architecture firm and have them produce a copy of the blueprint. They get charged $10, $12 for that. That's a documented expense. So they can, again, add that to the invoice that would be supplied to the requester that they have to pay before they get a copy of that blueprint. Okay, two very common examples, all right? The other one, analog recordings, I keep saying I need to take this out of the presentation because I don't know too many agencies that use cassettes or microcassettes anymore to record their meetings. Everything is digital nowadays, but it comes up periodically. You can kind of fill in the blanks and use your imagination to see how that works. Another one that we do encounter periodically are flash drives. This is when someone has submitted a right to know request and the response again is so large that it can't be transmitted as an attachment on an email. For instance, we use here at the Office of Open Records, we use the Commonwealth of Pennsylvania, the government's email system. And for security and also for capacity reasons, there is a limit to how big the attachments can be. And periodically, we have come up against that limit, especially if you're emailing back and forth legal documents, okay? That can get quite sizable. So there's a couple things we can do. Here, typically, we break down the attachment whenever possible and have multiple emails. But another thing that you can do, and we find this more common at local government level, is use flash drives to transmit electronic documents. Now, I'm going to get into this in the next slide, but if the agency were to have to purchase a flash drive, load the documents on it, and then provide that flash drive to the requester, they can charge for the cost of the flash drive. Again, it's a documented cost that they can provide a receipt for in order to respond to this particular right to know request. So they could add on the cost of that flash drive. But like I said, there's something to consider if you're dealing with flash drives. And let's get into that. Now, this is not part of the right to know law. Okay, there's nothing in the right to know law that says that if you are transmitting electronic documents by a flash drive, this is what you must do. Rather, this is what we would define as a best practice. A couple of years ago, when we were back doing live training pre-COVID, some local municipalities approached us and said, we'd like to try this out because we think it makes more sense. We took a look at it and said, yeah, this is a pretty good idea. Why don't you guys go ahead and do that? And we've advocated it ever since. Like I said, this is not part of the right to know law. You do not have to do this, but we suggest taking a look at it. And what the process is, okay, someone submits a right to know request. That right to know request is approved, and it's for electronic records. So rather than have the agency have to, and when I use the term agency, I'm talking about any government entity that falls under the jurisdiction of the right to know law. So rather than the agency maintaining a supply of flash drives and then having to charge for those flash drives, what they do now is require that the requester provide them with an unopened flash drive. And then what they end up doing, what the agency ends up doing, is taking the electronic files, moving them from their network computers over to a laptop computer. And then they disconnect the laptop from the network. Then the next step is that they take that unopened flash drive, which more than likely is free of any viruses or malware, plug that into the laptop, and the laptop will run its own scan of the flash drive. Barring any problems, then they transfer the records, the granted records, from the laptop to the flash drive, okay? And then the flash drive is disconnected, provided to the requester. That way there's no problems from the IT security perspective. You know, your IT shop is, you know, not having a heart attack. And now, because the requester provided the flash drive, the agency saves itself a lot of trouble and a lot of work with any potential invoicing for the cost of a flash drive. So it's really easier for everybody by following this process. So if you're not doing it, take a look at it. It's something that we advocate, and it might, you know, save you a lot of trouble, and it might save you from the risk of having your computer network infected, whether intentionally or not, by a virus or malware. Okay, what can't an agency charge? Well, they can't charge for labor, and this is written right into the right to know law, whether that be an hourly rate or a fixed fee. Now, some of you are thinking, wait a minute, I thought the legislature said we could charge for labor. No. Every so many years, a proposal comes up in the legislature where they advocate allowing agencies to charge an hourly rate for commercial requests. All right, and our office supports that. However, it's never made it either out of committee or been approved by votes in both houses in the legislature. So as of now, until that changes, an agency cannot charge an hourly rate. You can't charge for a legal review, whether it be by your in-house solicitor or some sort of special outside counsel. It's simply considered the cost of government doing business to have a legal review take place if that's necessary. You can't assess like a right to know processing fee. Every so often, if things get a little quiet, our administrative staff will go out and surf agency websites just to see whether their right to know information is up to date and consistent with the law. And we will find some agencies that say, if we have to process a right to know request, we're going to charge you $25. Well, you can't do that. That's not consistent with the right to know law. So we'll reach out and try and get things straightened up. Periodically, we'll also find an agency attempting to charge a redaction fee. They're saying that, look, if we provide you with a hard copy record or an electronic record for that matter, and we have to go in and redact certain information, we're going to add an extra $10 onto the cost of that record. Again, you cannot do that. That is inconsistent with the right to know law and inconsistent with the fee schedule for the right to know law. And like I said, if you look at the fine print, those footnotes down at the bottom, you're going to see how that's clarified. Scanning fees. I think everyone has kind of gotten used to this, but early in the life of the right to know law, we would get phone calls from agencies saying, look, if I have to make copies, I can charge 25 cents a page. But if I have to scan a record in to make an electronic copy, I can't charge. And it's the same wear and tear on my copying machine. Well, first offhand, in a subsequent slide that we're going to talk about, there's a very good chance that you don't have to scan in the first place, okay? But the bottom line is that you cannot charge for electronic records in the majority of cases. So, like I said, I think everyone has kind of gotten used to this and they understand it, but you cannot assess a fee for simply scanning a record in. You can't charge for electricity. There's a story behind that, but I'm not going to get into it today. And like I said earlier, you cannot charge for electronic records such as emails, Word documents, Excel spreadsheets, or various database files. Now, like I indicated earlier, if there is a dispute where the requester believes what an agency is charging or intending to charge them is inappropriate, that can be appealed just like any other right to know request. And if you're really interested in this topic, you can go look at our website, go to the final determinations database under appeals, and you can actually put in the term fees, and a couple dozen right to know final determinations will come up where the main issue was a dispute between what the agency was charging and what the requester felt was appropriate. And you can see how the office has ruled on this. And if you want to go into it even deeper, you can go into our court decisions database and see how the courts have ruled on various fee disputes with the right to know law. Okay, I mentioned about electronic records and scanning. And so let me talk about this, because this, again, is a fairly misunderstood area of the right to know law. And we go to section 701, and I'm going to paraphrase this and try to put it in English. Essentially, it says that a record shall be provided in the medium in which it exists. Okay, you've got that term medium. That means hard copy records versus electronic records. So what does this mean from a practical perspective? Well, essentially, an agency is only required to provide a public record in the medium that they have it in. So if someone requests, and this is not unusual, someone will submit a request for a record, and they'll submit it by email because it's easy, and they'll request that they receive the record electronically because it's easy and because you can't charge for electronic records. But if the agency has the record, but it's in hard copy and not electronic, two things. First, the agency is not required to scan it in, because that would be converting it from hard copy to electronic. Okay, let me repeat that. The agency is not required to scan in a hard copy record in order to convert it to electronic, simply because the requester would prefer to have it electronically. Secondly, the agency would respond back to the requester and say, we have that record, but we only have it hard copy. We don't have it electronically. So we'll provide it to you hard copy, but then we can charge you up to 25 cents a page. Are you willing to pay that fee? Some people are, some people aren't, but it helps if you ask before you make a copy, okay? Because they may balk at paying for it. Okay, so that's pretty much how that works. Now, let me go off script a little bit, because we often get questions about what we call difficult requesters or problem requesters, okay? And these are people, I'll just say that the vast majority of people using the right to know law have a legitimate issue, and they need a record in order to satisfy that issue, and they're willing to pay a nominal fee. But with a problem requester, usually what's happened is the relationship between an agency and that person has broken down for whatever reason. Maybe they don't like who got elected to council last time. Maybe they think their water bill is too big. Maybe they got a parking ticket that they didn't think they deserved. And now they've decided they're going to be a pain in the neck with this particular municipality. And one of the ways that they're going to be a pain in the neck is to weaponize the right to know law and submit a bunch of frivolous requests. Okay? Like I said, legitimate requesters are willing to pay a nominal fee to get a public record to solve their problem. Problem requesters usually are not willing to pay a nominal fee in order to be a pain in the neck. So you take it from there, whether you're a requester or working for an agency here today. And my experience, and previously I was the open records officer for the Office of Open Records, dealing with over 1,000 right to know requests a year, that problem requesters will go away if you can figure out a way to assess a charge. They'll just disappear. Okay, they're not a problem anymore. That's just based on my experience. Okay, so I'm off my soapbox. Let's get back on topic. And I want to talk about medium versus format, because this is still a fairly common issue with the right to know law. And it comes down to Excel spreadsheets, okay? Medium is hard copy versus electronic. Format deals with a specific piece of software and how it generates its product, okay? The output or the end result of using that software. And if you're familiar with Excel, you know that you've got a spreadsheet with cells in it, and behind those cells, many of them, is a formula that determines what's going to be presented in that cell. So early on in the life of the right to know law, agencies would receive a right to know request for a copy of an Excel spreadsheet. The concern from the agency was that, well, if we give out the spreadsheet, they'll be able to change the formulas and misrepresent what we provided them. Okay, well, I can tell you that despite that fear, I am not aware of this ever happening once in all those years. Furthermore, if it were to happen, that would be a legal issue outside the purview of the right to know law. The person is misrepresenting what they were provided. So there would be probably be some legal recourse that the agency could take if it became an issue. But like I said, I can't remember it ever happening one time. But this ended up getting appealed, okay? And it made it up into the courts. And the issue came down to, could the agency, rather than providing a copy of the Excel spreadsheet with the formulas, could they provide a PDF version of the spreadsheet? And if you're familiar with PDF, it essentially takes a picture of the spreadsheet. Well, the courts said, yes, you could do this because a PDF is a copy of the original. And under the right to know law, that's all the agency is obligated to do, provide a copy. So that's where everything started legally. Now, over the years, case law has evolved. And where we're at now, the law basically says that if the requester specifically says, I want a copy of the Excel spreadsheet, then you provide that to them. If, on the other hand, the requester doesn't specify Excel, they simply use the generic term spreadsheet, you can provide a PDF if you want, okay? And that's where we're at now. I think ultimately, one of these days the courts will say, look, if they request the spreadsheet, you give them the spreadsheet, and PDF isn't good enough, but that's kind of where we're at now. So just so you're aware of it. And then every so often we run into what's called a proprietary format, where given quirks of the software, usually it's security related, the agency cannot provide a printout, and they cannot provide an electronic version that can be read if you don't have a copy of the actual proprietary software. So they get a pass if that's the case. Sometimes we run across this with law enforcement. Every so often we'll run across a municipality that has some kind of in-house homegrown software that can't talk to outside email systems, outside software systems. And again, they get a pass. It's like they're unable to generate a record in a readable format. So we can't force them to go out and modify their software to do so. It's very rare. So, I'm not going to spend a lot of time on that. Let me get a sip of coffee here real quick. Okay, redaction costs. Earlier I mentioned that an agency cannot assess a redaction fee. But that's not to say that there aren't circumstances where an agency can charge as the result of having to perform a redaction. Yeah, let me explain what I'm talking about here. This is where the agency has received the right to know request and they've granted it. They're saying, we're going to give you this public record. However, on that record, there is a piece of sensitive data, like a social security number or a personal email or a home phone number, something like that. Okay, so in order to redact that sensitive piece of data, let's say it's an electronic record, but they don't have redaction software. So they have to print it out, take out a Sharpie or white out or something like that, cross out the social security number, then they need to scan it back in, and then they can send you the redacted public record. Well, an agency can charge for the piece of paper that they had to generate in order to effect the redaction. Okay, that up to 25 cents a page. So it's possible that they can charge for an electronic record. But I recommend that if that charge is forthcoming, before the agency goes through with it, they should reach out to the requester and let them know that we're granting it, but there's a good chance there's going to be a charge. Are you willing to pay it? Okay, that way it saves everybody surprises and possibly doing work that otherwise you wouldn't have to do. Now, what if an agency, pardon me, what if an agency has redaction software like the Adobe Office Suite? First offhand, I'll just say that all of the security concerns that were raised 10 years ago have been pretty much dealt with. We subscribe or ascribe to the FBI security protocols. And if the FBI says it's safe, then we say it's safe. For the most part, all of the redaction software that's out there that we're aware of is safe. So security is not an issue. Where we're at now is that if an agency has redaction software, the Office of Open Records position is that they should use the redaction software. We're not saying that you shall use the redaction software. Not yet, okay? We believe, just given the way the winds are blowing with the courts and some cases that are in the pipeline, that within the next 2 years, we'll probably have case law that says if an agency has redaction software, you must use it. Thus, you cannot charge for going through the exercise of redaction. Okay, but like I said, we're not there yet, but case law is important. You want to be aware of it. And I'm just saying that we expect to see something within the next 2 years where the courts are going to say, you must use the redaction software. Okay, and again, a redaction is where you have a public record, but you're saying part of that public record is not public. That can be appealed. And what should happen is that when the agency provides the record, in their response, they would say, we're granting the record. However, we had to redact some elements, sensitive elements, such as a social security number. So that's what's behind the redaction. And then if the person still wants to appeal it, they can. Okay, I just realized that we might have, let me see. Okay, it has not. Every so often, the chat feature doesn't advance if someone types in a question. And I was just curious to see whether we had any questions. So far, no questions. Okay, back on point here. So, remember, redactions are denials in an official sense of the word, so they can be appealed. So be careful what you redact. Okay, moving on. Let's talk about how an agency goes about charging fees for requests that have been granted. Now, earlier I mentioned the deadlines that are built into the right to know law. And if you've sat through the basics webinar that we do, I do get into this. I briefly mentioned, well, I talk about all the deadlines, but what I want to emphasize here today is that the deadlines refer to the responses, not when the records are actually provided. Okay? The agency, and if you look at the law and parse out the actual words, the agency is responsible for providing its initial response within 5 business days. It says response, not records. Or if an agency takes the extension, the 30 calendar day extension, that's to provide the final response, not the actual records. So the scenario could be that the agency receives the right to know request. It doesn't take an extension, but rather it provides its final response within the 5 business days. So essentially, and that response is granting the request. So what the agency can do is say, we're granting your request, we'll provide you with those records as soon as you provide us payment and your check is cleared the bank, okay? Which obviously that would fall outside of the 5 business days, or conceivably it could fall outside of the 30 calendar days if we're dealing with an extension. But I think this is a very important point. And again, it's one of those misunderstood points of the right to know law, where both the agency and requesters have come with the mistaken understanding that, well, I have to get my records within 5 days, or we have to give these records out within 5 days. No, that's not the case. You provide the response within the prescribed deadlines. And then once you receive payment, then if there's a payment involved, then within a reasonable period of time, which, again, it's a subjective term, but let's just say a couple days is reasonable, you provide the actual records. Okay. Now, what if the request is for a lot of records, and when the agency receives it, they do a quick, let's say it's one of those environmental studies that we were talking about. The agency does a quick analysis and determines, okay, the response is, the cost of the response is going to exceed $100. Well, there is a provision, Section 901 of the Right to Know law, which allows an agency to demand payment up front before they even begin processing the request. Before we even begin determining the exact number of records, we know it's going to exceed $100. So you send us a check for what we estimate to be the final amount, and then we'll begin processing. Okay, so let's say it's $200. Well, they can demand the $200 up front. When the check is received, when it clears the bank, then they begin processing the request. Once they finish processing, then they determine the exact amount, and whether it's a refund, a partial refund, or more money's needed, that gets taken care of, and then you provide the actual records. I like to refer to this as a security deposit, okay? It's built into the law so that someone can't submit a really big right to know request or demands a really big response. The agency processes it, says, we got all your records ready, send us a big check and we'll provide you with the records. And then the person balks on it, or they go off into the sunset and never pay. This way, the agency has the money held in abeyance while they're processing this big response, a security deposit, to make sure the agency doesn't get stiffed in the long run. Okay. The agency is not required to demand the security deposit, but they can, at the agency's discretion, do that. And like I said, you settle up on the exact amount once you determine the exact number of records. So that provision is available. Okay, record discard. This we don't encounter a lot, but nevertheless, it's in the law, section 905, and it allows an agency to discard any records that they've generated if a person fails to retrieve those records after 60 days. So that if the agency has granted the request, generated the records, and said, these records are available for you to retrieve, and then you'd never hear from the requester, the agency can get rid of the records after 60 days. And we're assuming hard copy here. You can destroy them in any manner you see fit. But the point that I want to make with this slide is that if the agency incurs a cost as a result of generating a right to know response, and the requester fails to satisfy that cost, they fail to pay for the records they requested, the agency can then deny processing any subsequent right to know requests from that individual. The debt does not go away. There's no statute of limitations. So if someone submits a right to know request, the agency grants that request, then the person fails to pay for it. 10:47 a.m. Okay, the person fails to pay for it. Then they turn around and submit another right to know request. The agency can say, you have an outstanding debt, and until that debt is settled, we're not going to process any further right to know requests. And it could be, for an entirely different set of records. Okay, a couple questions have popped up here. Can you specify in the right to know law where it says if they still owe money? Sure. Chris, you're not going to find it in the right to know law. It's actually the result of case law. And again, I would suggest going to our final determinations database and simply doing a search on fees or debt or something like that. And the various cases will show up, but I think you'll find that there is case law that supports it. You might even do better going to our case law index, which takes it from final determinations up to the actual state courts and how they have ruled on this issue. And that's why your solicitor can't find it in the actual law. He may want to try, or she may want to try doing a search using Westlaw or Nexus, and the appropriate provisions will come up. Okay, section 905 stating if an agency responds to a requester, says that copies of the requested records are available for delivery, fails to retrieve within 60 days of the agency's response, the agency may dispose of any copies which have not been retrieved. Yeah, that's section 905. Okay, Chris, I'm assuming that based on your own review of the law and my response that your thanks means we're good. Okay, good questions, by the way. Yeah, okay, good. Okay, so the point being section 905 gets into this whole idea of if a person has an outstanding debt, like one of those difficult requesters or problem requesters, that solves a problem for you with any subsequent requests. And how you go about collecting debts is outside of the purview of the right to know law. Right to know law does not deal with the payment process per se, how you collect your fees, or how you collect outstanding debts. All right. However you do that as a municipality, until we hear differently from the courts, I think that's okay to do that in relation to the right to know law. The final determinations database I can't send you the link because I'm not online right here, but just go to our website and go across to right to know law, and you'll find, it may not be called final determinations database, but search around the site and the various links. You'll learn something by doing that anyway, and you'll get into that database. And yeah, okay, thumbs up, looks like you found it. It's really, I'm going to talk about our website here at the end of the presentation, which is, by the way, the best government website you'll ever find. And that database is a really useful tool to use if you're learning about the right to know law. Okay, let's move on, folks. Yeah, no surprises. You kind of probably gathered my approach to all this just based on some of my comments, but there is nothing in the right to know law that prevents an agency from talking to a requester and vice versa. Okay, if an agency gets a right to know request, and let's say it looks like there's going to be a cost involved, reach out to the requester, send them an email, pick up the phone and say, hey, I think our response is going to cost about $30. Are you okay with that? Most people are going to say, yeah, I was kind of expecting that. That's not a problem. But there will be some who say, oh, wait a minute. I thought the right to know law was free. I'm not going to pay any money for this. Never mind, I'm withdrawing my request. Okay, it could save you, the agency, a lot of work and headache in the long run if you just talk to the requester. And sometimes the request isn't clear. So clarify it with them. Make sure you're all on the same page. Requesters, on the other hand, when they submit a request, they can, for instance, say, if the response is going to exceed $10, give me a call first, or I don't want to go any further. All right, that's perfectly legitimate. They can legally do that. But whenever possible, an agency should provide an estimate so that the requester can decide whether they want to move forward. Now, as part of the right to know law, an agency cannot force a requester to tell them why they're filing a request. But the law doesn't say an agency can't ask. And I say that so that every so often it helps solve a problem. Let me kind of expand on this a little bit. If someone's submitting a right to know request, it's usually because they have a problem. So let me use an example here. Let's say it's a business owner within a borough, and they're having some issues with the IRS and their quarterly tax filing. And the IRS has said, well, in order to support this deduction that you want to take, we need documentation from the municipality that supports XYZ. So the person, they're not sure, the business owner is not sure of the exact record that they need, but they're able to gather that the borough has it. So they submit a right to know request to the borough, and they cast a rather broad net, and they figure that record is going to be somewhere in that broad net. So I'll just take my chances and hope that what I get back is what the IRS is looking for. That's a fairly common approach that requesters take. Now the borough, they're looking at this from the exact opposite perspective. They're hoping that the request is very specific, that they even put the form number on the request so that they can spend as little time and as little effort as possible getting this right to know request off their desk. But they get this really broad request. So I found that the solution is for the agency open records officer to pick up the phone, call the requester, and have a conversation. And it would go something like, I'm not sure you realize how big a request you're submitting, how much work's involved, and how much that's going to cost you for all these records. Do you mind telling me why you are submitting this right to know request? Okay, now the person doesn't need to tell them. They can, blow them off and say, it's none of your business. I don't have to tell you. Or they can realize, oh, here's someone who's trying to help me. Well, I need this record because of some issues I'm having with the IRS. And they're saying I need to document this particular deduction that I'm taking. Hopefully, the agency open records officer can recognize, oh, well, we deal with that fairly often with businesses in the borough. I know exactly what they're looking for. I can have that ready for you this afternoon. Everybody's problem is solved simply because they were talking to each other, okay? Communication is good. I think you get my point. I'm going to come down off this soapbox, but like I said, there's nothing in the right to know law that prevents these conversations from taking place. Okay, couple final points here as we're wrapping things up. Certified records. This is in the right to know laws, section 1307C. It allows an agency to charge $5 per certification. Okay, what's a certified record as far as the right to know law is concerned? It is where someone is submitting a right to know request to retrieve records that are going to be submitted to a court. In most cases, the court is saying you can't just throw paper at us. You need to provide us with the certification that these records are accurate. So what the agency open records officer will do is prepare a statement, a certification, authenticating that the records are true and correct copies of the originals, no more. They are not certifying the provenance of the content of the record. They're not saying what this record says is accurate. They're simply saying the copy is an accurate representation of the original. That way, the courts know that the record has not been altered by the agency in any way. That's the only thing they're certifying. Example language you can find on our website. We have an agency open records officer guidebook. In there is sample language that you can use for certifications. Transcripts. Let me go into this because this comes up periodically. A transcript is a verbatim record of what was testified to and what was spoken at a hearing. Okay, so you've got zoning hearings, you've got, well, let's just use zoning as our best example. So someone will submit a right to know request for a copy of a transcript. Okay, maybe, they're considering an appeal, or maybe it's under appeal or whatever. Transcripts are considered public records only when a two-part test has been satisfied. The first part of that test is fairly easy. It's all appeals must have been exhausted. Okay, well, it could be appealed, if it's a zoning issue or a code issue. That's probably the better example, the code issue. It could get appealed up to the elected officials. It could get appealed to the county court, maybe Commonwealth Court, maybe Pennsylvania Supreme Court. Okay, that could take years, okay, but all appeals must be exhausted and it cannot be appealed any further. Okay, so that's the first part of the test. The second part of the test gets a little trickier, and that's where the transcript must be in the possession of the agency. In this case, in our example, the borough. And that doesn't always happen, Because the way this usually works is most agencies don't have an in-house transcriptionist. Rather, they contract with a stenographer who, when you have the hearing, they come in with their machine and produce the verbatim transcript. They get paid a standard fee for being at the hearing. Usually it's some sort of hourly rate. Then they generate the transcript, which usually costs a couple dollars per page. Depending on the nature of how the dispute progresses, if it has to go to court, it gets appealed or whatever, the agency may opt not to actually purchase the transcript. So they pay the transcriptionist the hourly rate, but don't pay the per page fee for the transcript. So the transcript is in the possession of the stenographer, not the municipality. If that's the case, the requester is out of luck as far as the right to know request is concerned. They have to go to the stenographer and pay that hourly or pay that per page fee. Now, if the agency has purchased a copy of the transcript and all appeals have been exhausted, then it's in the possession of the borough and it's a public record. So you end up paying for the transcript and you only have to pay 25 cents a page, up to 25 cents a page, not the hourly, why do I keep saying that? Not the per page fee that the stenographer. Now the stenographer gets wind of this. They might say, oh, wait a minute, that's my transcript. You have to pay me my per page fee. The Office of Open Records has ruled that because it's in the possession of the agency, it's their property. They paid for it, and under the right to know law, it's a public record, and if they give it out, they only have to charge up to 25 cents a page, and that's what the requester pays. So that's how you deal with transcripts. Now, if you have a transcript generated under the municipal zoning code, that's a different animal. You want to look into that, but I think the right to know law still applies in that particular case. Okay, wrapping things up here. Yeah, final page. If you have any questions, any more questions, now's the time to get them in. But I want to finish up just talking about the website. Okay, you've heard me refer to this a couple times. You've heard me say it. The best government website you'll ever encounter. There are all kinds of resources on there that give you information about the right to know law. Guides for citizens, guides for agencies. I mentioned the Open Records Officer Guidebook, 78 pages you can download for free, get all kinds of information, and it will be of good use to you. I mentioned those various databases. We've got digital electronic certification. Yeah, that's an interesting point. I'm just thinking here. Okay, I don't think it's ever been dealt with. I don't think it's ever been litigated. But without having the law in the specific language in front of me, I don't think the law distinguishes between certifying hard copy records and certifying electronic records. So I think an agency, even though they cannot charge for electronic records, they can still certify and charge for certification if that's what the requester is asking for. They can provide a document that says these electronic records are true and correct copies. And yes, I think and understand, I'm winging it here. I would say you could still charge the $5 per certification
not $5 per record. Okay, let's clarify that. Yeah, for electronic records, I think you can do that. It's a little harder for electronic records because being digital, they're easier to manipulate. But I think you'd be okay doing that. But it's $5 per certification, not $5 per record. Okay, this website is updated 6 days per week. New decisions, new training opportunities, just new news in the world of government transparency. And by the way, if you're a real geek with government transparency, subscribe to our X feed every morning at 7 a.m. We will wake you up with all the news of the day related to government transparency, decisions that our office has made, court cases, and the like. Finally, if something comes up that you need to get an answer right away, reach out to our office, okay? Call us, send us an email. We will do our best to get you steered in the right direction. We can't provide legal advice. We cannot write requests for you. We cannot write responses for you. We can't tell you how we're going to rule on an active appeal, but we can try and get you steered in the right direction as best as possible. So feel free to reach out to us. Okay, that's it, folks. We had a good presentation today. Hopefully you learned something from this, and I appreciate your questions. So we'll be back in 2 weeks with another webinar on Office of Open Records activity. So have a good afternoon, folks, and hopefully we'll see you soon. Take care.